This is Jason Lazarus. I'm the CEO of Synergy Settlement Services, and I wanted to welcome everybody to our Medicare Secondary Payer Summit. And the purpose of the presentation is to give you guys basically the lay of the land when it comes to total Medicare compliance, which has become a very prominent issue in most personal injury practices. And I'm guessing if you're signed on a Friday afternoon to listen to us talk about Medicare, that this is a topic that you are interested in. Synergy allows trial lawyers to focus on what they do best by handling the difficult issues at settlement, such as healthcare lien resolution, Medicare compliance, public benefit preservation, settlement planning, and a number of other services that can be helpful to your practice. Today's first speaker is Josh Pettengill, who oversees the Medicare Secondary Payer Compliance Group for Synergy. Josh has a very deep background in Medicare Secondary Payer Compliance. He's a Medicare Set-Aside consultant certified and has served in numerous capacities with the NAMSAP, which is a regulatory group that oversees the Medicare Secondary Payer Compliance practice companies such as our company. So he is quite the expert, and we are lucky to have him today. And with that, I will turn it over to Josh to get started with his presentation.
Thank you, Jason. Again, I want to welcome everybody for joining us on a Friday afternoon. A couple little housekeeping items. Today is actually National Camera Day. For those of you that didn't know that, I didn't know that until this morning, but we're actually recording this presentation, so you will be able to rewatch this if some people from your firm aren't able to participate today. And I also want to encourage those who haven't signed up for any of our Third Thursday seminars to hop on those. Those webinars are usually about 45 minutes long, and they're offered every single month on various topics. So please take a look at those. And with that, I'm going to get started. So here's an overview of our plan today. We're going to be hitting all these topics throughout the day. There'll be some crossover. There'll be some deep dives in all these different issues. And literally, we could talk for Medicare for 3 weeks straight if we wanted to. And we have done 3-day seminars, but today we really want to focus and drill down with laser focus on these different issues that you as trial attorneys see in your practice every single day. And we're going to kick things off with Medicare Set-Asides. And I'm really going to focus on the liability side of things today. We are going to hit some workers' comp, but for the most part, we're going to be covering liability Medicare Set-Asides. So I'm right now into the World Cup. Unfortunately, the USA is not playing this year. Sweden is still left in the tournament. My mom's from Sweden, so I have a rooting interest for Sweden. A lot of you may be watching the World Cup right now as we speak. I don't know. But you may remember a few years ago, Tim Howard was an all-star god almost for the United States team several years ago. And at the time, he was unbelievable, goalkeeping every single thing that went his way. He actually broke the record in the World Cup with 16 saves, one game. And at the time, also, they had these funny memes that were coming out. We need him to save Darth Vader and Luke Skywalker. We need him to save Ned Stark. We need him to save everything. Well, right now, we need to get him out of retirement to save Medicare. The way things are going. Medicare right now, for those of you that have been following along, is a very broken system, right? And most recently, they said that the Medicare Trust Fund is going to go broke a little bit earlier than expected, supposedly in 2026. What does that mean practically as a trial attorney? Practically speaking, there are a lot of issues that are coming out, especially most recently here, this Department of Justice case, which Dave Place, our Director of Lien Resolution, is going to talk more about. But the Medicare system is struggling, and liability Medicare Set-Asides is a potentially low-hanging fruit for Medicare as far as preserving the Medicare Trust Fund. And I'll talk a little bit more about that as we go through this. But how many of you on this presentation have heard that a Medicare Set-Aside is required under any of these two circumstances? Number one, you have a client that's Medicare eligible and the case settles for $25,000 or more. Or number two, the client's is going to be eligible for Medicare in the next 30 months and this case settles for $250 or more. I get that call 15 times a week. Say, Josh, I've got a question from the defense attorney, from the adjuster, said we have to do a Medicare Set-Aside under these circumstances. And nothing could be further from the truth. So I call it fake news. Fake news is another hot topic right now. A Medicare Set-Aside is never required by any law or by any statute, okay? Those two thresholds I just read to you are exactly that. They're thresholds. They come from workers' comp, and it's dependent on workers' comp when they actually meet those thresholds. CMS will actually take the time to review and approve a submitted Medicare set-aside, assuming they have the workload to support that and review those. Okay, and other fake news. How many of you here on this call have heard that trial attorneys have stiff penalties and face stiff penalties for not doing a Medicare set-aside, or that CMS can go directly after the plaintiff attorney for not doing an MSA? Or the MSA is a defense issue. All these things, again, aren't truths. They're not truths at all. So as trial attorneys, as you're on the plaintiff side, your exposure is that not educating your clients on these potential issues, such as Medicare set-asides. And what I mean by that, when it boils down to it, from Medicare's standpoint, they don't want to be stuck paying the tab. If Grandpa Jones falls and gets hurt and settles the case for $100,000 and collects money for future medicals, Medicare doesn't want to be stuck paying the tab for that if they know Grandpa Jones has been compensated for future medicals from their standpoint. Couple key takeaways. Number one, a Medicare set-aside is never required. Even in workers' comp, it's never required. There's a big misconception that Medicare set-asides are required. I'm going to keep hammering you on that. They're never required. So if you're ever in a situation where a defense attorney or an adjuster is telling you you have to do a Medicare set-aside, that's not the truth. And today we're also going to talk about alternatives to doing Medicare set-asides. Our last third Thursday webinar about a month ago, we talked about this, but we're going to hit it again as far as what alternatives there are to Medicare set-asides. If you're taking notes, here's what you really want to write down. You're going to hear me say this multiple times today, okay? What's the litmus test for us when you want to actually consider doing a Medicare set-aside? Number one, you have a client that's Medicare eligible. Number two, you have a client that may have to treat in the future or the doctor is potentially recommending treatment. And number three, there's actually money there to fund future medicals, okay? When those three criteria hit, you want to at least consider and have a discussion with your client about the potential for a Medicare set-aside. Now, all this goes back to 1981 when we had the Medicare Secondary Payer law. Whether it's right or wrong, whether you believe it or not, it says anytime there's workers' comp, no fault or liability insurance, Medicare doesn't want to be known as the primary payer, okay? They don't want to be stuck paying the tab. How many of you have that friend or family member that when you go out to lunch and the tab comes, they're running to the bathroom or they're ducking underneath the table? This slide really sums that up. As my partner, Dana Alvarez, says, that's how Medicare does. Medicare doesn't want to be stuck paying when they know that somebody else at the table has money that can pay for that treatment going forward. Just an easy way to remember it. They don't want to be stuck paying it until their interests have been properly considered. What do I mean by that? So going back to 2001, 20 years post the Medicare Secondary Payer statute, Medicare issued a series of policy memorandums starting in 2001. It was called the Patel Memorandum, okay? And the Patel Memorandum really was the advent of the Medicare set-aside. It gave Medicare a mechanism or a tool to actually deny treatment on the basis that it should be paid out of a Medicare set-aside account. Since 2001, we've gotten the Stalcup memo, which says that there's never a requirement to do a Medicare set-aside, and also bifurcates out the lay of the land as far as the settlement parties' roles are concerned as relates to a Medicare set-aside, which Jason will talk about. And then we also have a situation from CMS where it provides an exception to when you don't have to do a Medicare set-aside. And I hope you don't have a lot of cases like this, but if you ever have a situation where your client doesn't have to treat in the future and a treating doctor will actually put that in their letterhead, short and sweet, it gives an exception as to when a Medicare set-aside does not have to be done. And as a takeaway to this presentation, we will send you some template language if you want for your files in the future, or you can actually provide that template language to your treating doctor for your plaintiff so they can know what to write in that letter. There's no place where you can go on the website or anything like that on CMS's website to download that information, but we'll send it to you. So what is a Medicare set-aside? I'm in mediation about 3 times a week, as are my partners, and we typically talk about Medicare set-asides at the end of the mediation when it should be talked about at the beginning of the mediation or well before the mediation even gets there. And this is the reaction we typically get when we ask somebody, what is a Medicare set-aside? They look at you funny like they've just seen Bigfoot. They don't know what a Medicare set-aside is. Well, short and sweet, a Medicare set-aside is exactly what it sounds like. It's literally money that's set aside in a separate interest-bearing account to be used and earmarked for future accident-related care covered by Medicare ordinarily, okay? I'll repeat that. It's just money set aside in a separate interest-bearing account that's earmarked for future accident-related care that Medicare would ordinarily pay for. It's short and sweet. It's like a deductible in the sense that, let's say we have a $5,000 Medicare set-aside. Once that $5,000 has been spent appropriately, their client is back on the hook, meaning Medicare is back on the hook for paying for that future care going forward. Now, best practices, if there's going to be a Medicare set-aside set up, is to use that money out of the gate to pay for that care. And we'll talk more about how that works practically speaking as we go through this today. But the purpose of actually doing a Medicare set-aside is multifold. It's number one, clearly it's Medicare's preferred method of protecting their future interests. Even though Medicare says, look, you're never required to do a Medicare set-aside by any law, by any statute. However, the Medicare trust fund has to be protected, right? And our preferred mechanism of doing that is a Medicare set-aside account. That's best practices. So clearly, for the injury victim standpoint, what we don't want to happen is you settle a case, like in the old days when you settled a case, you didn't have to worry about Medicare ever denying something or not paying for something. As long as that conditional payment was paid back and Medicare issued their closure letter, you had no worry or concern that Medicare wasn't going to pay ongoing. That has gone away more recently over the years. And more typically in the last 2 years, we've seen a spike in those denials where Medicare has actually denied something for one of our clients, or they've come back after the fact and said, you know what, we made a mistake and we shouldn't have paid this. And oh, by the way, you have 60 days to pay us back or the interest starts running. So it's a very, 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 very low risk. I want to stress that. I can't stress that enough. Over a span of tens of thousands of cases, we've probably seen it happen less than 30 times where that's happened, but it's picked up a little bit over the years. I was a skeptic that Medicare, even myself was a skeptic that Medicare would ever deny something, but we started to see it happening more frequently a little bit. And clearly from a trial lawyer standpoint, you want to make sure your law firm is protected, because the risk that you run is that not educating your clients on these potential implications of Medicare not paying potentially or coming back after the client and saying, look, you owe us money after the fact. You got to talk to your clients, okay? And if you do a Medicare set-aside, you have no doubt, assuming that money is spent appropriately, that nothing's going to happen as far as a disruption of benefits to your plaintiff, your claimant. So again, as a trial attorney, you got to have those discussions. You got to document your file, what was said, what the plaintiff elected to do, and then you can go on to the next case. Here's your litmus test. I'm circling back to it again. Number one, Medicare eligible. How do you have a client that's actually going to be eligible for Medicare? There are a few different ways. Age 65, which is we all know on this call, Social Security disability benefits for 24 months, end-stage renal disease. We've had an influx of these cases. These are really sad cases where our clients have an end-stage renal disease, very complex from a Medicare set-aside standpoint. A Lou Gehrig's disease, or a child is disabled with a deceased parent or a disabled parent. Very rare to see a child on Medicare, but we touch so many cases and so many catastrophic cases that we do actually see quite a few of these, but it's very rare, okay? So these are the only ways your client can be eligible for Medicare. So it's important when you're intaking that case to make a checklist, which I'm sure a lot of you are already doing, to drill down as far as what benefits your client may be eligible for, not only now when you're intaking the case, but potentially in the future. And there's a document that we can give to you as a takeaway to this presentation that you can stick in your file. It's short and sweet. It's literally a one-page document where your client can go down to the local Social Security office, give them that letter, that one-pager, and they can find out exactly what benefits they're eligible for, okay? Number two, future accident-related care is claimed, or they're going to have to need it in the future. So you may have a situation where you have an IME saying, okay, you may have to treat in the future, or there's maybe no future treatment, whatever the case may be. From the CMS's standpoint, it holds no weight, okay? CMS is looking toward what the treating doc is saying is going to be required. And if you're actually making a claim for future medicals and or the case is being released to future medicals, you have a potential scenario where Medicare is going to be put on notice. And number three, funding for future medicals. This is a tough one because there are a lot of cases where arguably every single case in liability settles for a reduced or compromised amount. I can make that argument if I'm testifying that any case almost settles for a reduced or compromised amount, whether you take into account procurement costs, whether you take into account specialty damages, whether there be situations where you have liens or past conditional payments that are higher than the total recovery. There are a lot of situations where it may be clear that future medicals weren't funded, nor were they claimed, obviously. They're very clear-cut situations when it's like that. But oftentimes where the water gets muddied is on this future medicals issue. But if again, number one, Medicare eligible, number two, potential for future care, and number three, future medicals, you want to consider at least having a discussion with your client about doing a Medicare set-aside. And if the answer is yes to all three of those things, best practices would be to do a Medicare set-aside. And a Medicare set-aside can be informal or it can be formal. Informally, what does that mean? Is literally your client just takes some money, opens up a separate bank account, and says, I'm doing a Medicare set-aside. You can put that as a line item in your closing statement. It's still better than doing nothing. Now, if you have a catastrophic case or a case that's very clear-cut, you may want to consider doing a professional analysis where we have experts involved to come up with a recommendation. The difference between option one, informally setting aside number two, is that you have some due diligence to support the recommendation behind the number, and also have a team of experts that can go up against Medicare if they have to. Finally, a quick takeaway. I've said it 65 times. I will probably say it 75 more times today. Again, Medicare set-aside is never required, but that doesn't mean that there won't be potential consequences in the form of maybe your client getting denied care for something, or maybe CMS coming back after the fact and saying, hey, you owe us money. And I've mentioned this on other webinars and previous webinars, but as a trial attorney, it's incumbent on you on the plaintiff side to talk to your client about this issue. More and more frequently, the defense is making it their business, but it's a plaintiff issue. No matter what they tell you, it is a plaintiff issue. It doesn't have any impact on the defendant as far as this Medicare set-aside is concerned. Now, the defendants have the deep pockets, therefore they're worried about the issue, but it's on the plaintiff attorney. So a few years ago, I got a call from an attorney down south who said, Josh, you got to come meet with my law firm right away, and I've got a situation. So I fly down there. He says, I settled this case 2 years ago for $80,000. And oh, by the way, Medicare is now refusing to pay for a shoulder surgery for my client. Now my client is now threatening to bring action against me in a legal malpractice suit. First time I'd ever seen that happen. I haven't seen it happen since. I hope I never see that happen again, but it is a real risk nonetheless. And finally, this is, if you do a Medicare set-aside, you know that its best practices, your law firm is going to be protected, and your client's going to be protected. And with that, I'm going to pass it over to Jason Lazarus. Jason is the CEO of Synergy Settlement Services. As he mentioned, Jason has served as an expert witness on many of the landmark cases actually in this area. He's got an elder law certification. He's also a board certified Medicare set-aside consultant as well.
Thanks, Josh. It'll take me 1 second to get my presentation pulled up. So as Josh said, I'm going to talk about Section 111 reporting, which really is the genesis of why Medicare has become such a hot topic and hot button issue with defendants and insurance carriers, because there was a bit of hysteria over Section 111. But this whole area is very confusing. You've got the Medicare Secondary Payer Act, you've got mandatory insurer reporting, and you've got MSAs. And for most lawyers, it's just gobbledygook. But it's all tied back, as Josh said, to the Medicare Secondary Payer Act. And the mandatory insurer reporting requirement really is, at its heart, designed to make sure that Medicare is aware when a PI case settles involving a Medicare beneficiary. So Section 111 of the MMSEA, which was signed into law in 2007 by then President Bush, is what created a reporting requirement that is separate and apart from the plaintiff's obligation to report when they're resolving a personal injury case. So the Section 111 reporting is applicable to non-group health plans, so that includes liability insurers, no-fault insurance, workers' comp insurance, and it doesn't change any of the responsibilities to report that the plaintiff has. But the purpose of Section 111 is simply to verify any and all primary payers in incidents involving Medicare beneficiaries, so that Medicare can recover if they've made conditional payments. And this new section, when it was passed, didn't eliminate existing statutory provisions or regulations. It doesn't change anything. It adds on to what already was there and puts additional obligations and potential penalties on insurers for failure to comply. So what MIR or MIR does is it affirmatively identifies Medicare beneficiaries and notifies Medicare of a possible recovery for conditional payments that were made on behalf of the liable party, and it effectively identifies every settlement involving a Medicare beneficiary. So now the reporting requires any settlement, and it's called a TPOC, which is just an acronym. So any settlement of $1,000 or more, gross settlement, is going to be reported by the defendant insurer to Medicare. That is their requirement. So the parties that are required to report are what's called RREs, or responsible reporting entities, which is basically the liability insurer, no fault, or workers' comp. The RREs can use a reporting agent, so some of them will outsource to a reporting agent to report to Medicare. And the information that must be reported is pretty detailed. And really what's most important about it are the dates of birth, social security number, date of accident, the injury-related diagnosis codes. All of those things are what is getting reported to Medicare, and it's done electronically. They cannot do it any other way, the insurer. So it's basically a data dump. And what can be really problematic is what is reported as the applicable injury-related diagnosis codes, and I'll explain why in a moment. So the question is, why did Medicare set up this reporting requirement? Because, prior to this, plaintiffs had the obligation to report anyway. So why do you need this? The stated rationale is because Medicare wanted to make sure that they were recouping any monies that they paid out that were conditional payments. But the bottom line of that is that Medicare's got a plethora of avenues and parties to pursue if Medicare isn't paid back, and attorneys, you guys who represent the plaintiff, have personal liability. So it's pretty rare that Medicare is getting cheated out of money. It really is part of just this larger framework of implementing the Medicare Secondary Payer Act, more teeth, more ways of getting information. And from Medicare's standpoint, they want to make sure that they preserve the Medicare trust fund as much as possible when it should not be paying, which according to the Medicare Secondary Payer Act is any time there is insurance available to it. So the bottom line of it is that they're collecting a lot of information, and part of it is for making sure that Medicare isn't paying when it shouldn't be paying, which is why we're focusing quite a bit of time on the Medicare Secondary Payer Act and Medicare Set-Asides and futures. We're going to talk about conditional payments and resolution of Medicare conditional payments, but that's more automatic. This is a little bit more sinister, a little bit more Big Brother-ish now. But the impact of mandatory insurer reporting on personal injury settlements is that it basically has created more administrative obligations and costs for the insurers. It gives more visibility to Medicare claims for all the parties and for Medicare. Conditional payments have to be appropriately addressed, which is why you're seeing releases with tons and tons of language in it related to the Medicare Secondary Payer Act and about conditional payments because of this exposure. And then the settlement documents have become more complex. There's certainly releases I see pretty regularly where I'm asked to review them by plaintiff counsel, where it goes on for 5-6 pages, and it's typically gobbledygook and doesn't make any sense, and sometimes have language saying that the injury victim won't ever apply for Medicare, won't ever apply for Social Security disability. Pretty ridiculous stuff. So, one of the issues that arises as a result of the mandatory insurer reporting, and why I've got it here as a practice point, is when the ICD codes get reported, that allows Medicare to flag care, meaning the common working file that Medicare and Medicare treaters work off of is noted that those ICD codes are injury related. So say you have a simple auto accident where neck and back injuries were claimed. Throughout litigation, the defendant takes the position that the neck is pre-existing, and ultimately the case gets settled, but really the dollars they're paying are for the back injury. If that insurer reports neck and back ICD codes, what could happen is the client could have a problem where Medicare denies future injury-related care due to a settlement that funded future medicals if they believe that the neck was part of that. So that's where you really have to make sure you know what's being reported. One way to do that is you could document in the release what the ICD codes are that the defendant will report, defendant insurer, or a separate writing. But you really need to know what ICD codes are being reported. Not only that, but date of accident too. We've had situations where a different date of accident gets reported than what was originally reported to Medicare by the plaintiff, and that can cause an additional conditional payment letter to be issued, which can be a problem. So you really have to make sure you know what's being reported, and there's no way for the plaintiff to access that information. Medicare will not give it to you. You can't see what was reported. So you've got to make sure that you're coordinating with the other side and figuring out what it is that's being reported. The future interest being addressed is something that's one of the byproducts of mandatory insurer reporting because of the insurer's misunderstanding of it and misinterpretation, but it's nonetheless an issue, and frequently we see settlement agreements that talk about just an arbitrary amount being set aside, which is probably worse than setting aside nothing. And really the bottom line of all of it is that there needs to be a legal analysis as to what should be done under the Medicare Secondary Payer Act. No LMSA at all as to why you did that, but what I would certainly caution against is accepting release language that talks about Medicare Set-Asides, because typically it's just flat out wrong, and oftentimes it imposes obligations that don't exist under the law, and you never want to have a client signing off on a release that has language in it that is legally incorrect. You can address the Medicare Secondary Payer Act in one paragraph. There's no need for six long pages of it all. So that's where a group like us, who has the expertise, can help you guys navigate that sort of thing. So the reason that all of this has become really important is because with mandatory insurer reporting, it gives Medicare an easy way to deny future injury-related care. And the problem with that is if that happens to your client, there is multiple levels of appeal that they have to go through within the agency before they ever get to a federal district court. And there's a bunch of case law out there that supports Medicare's position that if you do not exhaust, then you cannot have the federal district court hear it, because the district court doesn't have jurisdiction to hear it until exhaustion of the administrative process is done. So that means if a client gets denied care, they could wait a very long time, over a year, before they see the inside of a federal district court to get the proper relief, which is why it's important to know what's being reported and why the release language becomes that important. So what do you have to do in your practices to be compliant with all of this stuff in Section 111 and mandatory insurer reporting is making sure that when you intake a new case, you're verifying Medicare eligibility and doing your reporting, the plaintiff's obligation when you resolve the claim. Obviously, you've got to resolve the Medicare conditional payments and pay the Medicare final demand. You've got to make sure that you provide the information to defense counsel for accurate reporting, and then make sure the defense reports the proper ICD codes and the date of accident, just making sure that accurate information ultimately gets provided to Medicare. So that concludes what I'm going to talk about. Briefly, I just wanted to show graphically what Synergy does. So Synergy helps trial lawyers from the time the case resolves, from lien resolution to Medicare compliance to government benefit preservation, structured settlements, trusts, and then ultimately tax deferral of fees. So this shows you kind of from start to finish how Synergy can help you guys in your practice. So with that, I am turning it back over to Josh, and Josh is going to continue with the next presentation.
Thank you, Jason. As I'm loading up my presentation, I just wanted to pile on to what Jason already said, that as far as the reporting requirements are concerned, there's something called a common working file, or a Medicare common working file. Okay, why is that important? It's important because when that case gets reported, all that information goes in to that common working file. And the common working file talks about eligibility requirements, when the claimant became eligible for Medicare and what they're entitled to, all those things. So all that Section 111 data piles into that file, that common working file, which allows potentially the ability for Medicare to deny something on the basis that it's directly correlated to that case. And the last other thing I want to mention is that a case can't be reported without a Medicare number. So a lot of you on this call are getting those requests from defense counsel or the claims adjuster saying, give me your information about your client. You don't have to give it to them, nor do they have to share with you what they're reporting. But it's important to communicate on the front end all of those things, and on the back end, as Jason mentioned. So let's assume you're in a situation where you've actually decided and assume that you have a client that met all three of those criteria we mentioned. Number one, Medicare eligible. Number two, future care. And number three, money. Okay? And you say, Josh, you know what? I need some help. I need some assistance. I want to go ahead and do a Medicare set-aside. So this presentation is really going to fly through. I'm going to get us caught up on timing. What goes into doing a Medicare set-aside? So Synergy has nurses on staff that do nothing but specialize in preparing Medicare set-aside reports. We also do medical cost projections. That can be a great tool to build value on a case and show damages. But our nurses, that's all they do in this area, is review medical records and make the appropriate recommendations. So what all goes into the analysis? Okay. Well, clearly we take into account pre-existing conditions. We never want to allocate for things that aren't related to the accident. In our situations where it's a little tougher, when you have pre-existing and exacerbation of injuries, then it becomes a question of bifurcating out what the pre-existing injuries were and what additional care would be needed. Accident injury-related medical conditions, that's the biggest driver of the value of the Medicare set-aside account. I want to be very clear about something. When we get involved, if we ever get involved to do a Medicare set-aside, the end game, the end result, post-settlement, not pre-settlement, is to get the lowest possible Medicare set-aside number we can justify to Medicare to make sure everyone's protected. That's what we specialize in doing. Recommended medical treatment, rated ages, all these things determine what the Medicare set-aside amount is going to be. So when you drill down through it, a life care plan, for example, has many modalities of medical pieces. Whereas a Medicare set-aside, if you get a report from us, or from anybody for that matter, it's going to be broken down into two things, okay? Medical expenses and drugs. And on average, drugs make up about 65% of the total MSA amount. And it's based on the person's life expectancy. Why is that important? Because Medicare allows us to use what's called a rated age. And a rated age is a substandard life expectancy that's assigned to individuals. A healthy 50-year-old male may have a life expectancy of 30 years, but if you look at the healthy person's condition, if they're a quadriplegic or a paraplegic, maybe they have a life expectancy of a 75-year-old man instead of a 50-year-old man. So that's important because a rated age can seriously drive down the cost of the Medicare set-aside, and CMS allows for that. Whereas with a life care plan, it's the opposite initiative. The goal is, how long is this person actually going to live? It's based on a normal life expectancy. So we get this question a lot. How do we price these Medicare set-asides? So one of the ways we have to price liability is based on what's called usual and customary fee schedule. It's similar to cash pricing. And you might be gasping right now saying, why on earth would you price it at usual and customary fee schedule? Well, that's what we're supposed to do according to the CMS methodology. And in workers' comp, most states have set fee schedules, and the states that don't have set fee schedules, we also have to be priced at usual and customary fee schedule. the key takeaway here is it's not based on the Medicare approved amounts, which are much, much lower, as we all know. So as a practical point, some of our clients, what they're doing is taking a wait-and-see approach to whether or not Medicare is going to pay, even those that have set up Medicare Set-Asides. So they're funding this Medicare Set-Aside based on usual and customary fee schedule, but they're actually seeing if Medicare is going to continue to pay. And if they do continue to pay, that's on Medicare. But if Medicare ever comes back and says, oh, hey, wait a minute, we made a mistake, well, guess what? They're going to be paying back Medicare at the Medicare allowable rate, which is a much lower rate. Just something to think about. Now, clearly, a life care plan versus a Medicare Set-Aside, a Medicare Set-Aside is only going to contain the Medicare covered items, whereas with a life care plan, it's going to include everything under the sun, as we all know, both Medicare covered and non-Medicare covered items. For us, if we're doing a report or analysis, we will oftentimes include the non-Medicare covered items as just a complementary, as something that our clients want to see if potentially they're using our report to establish damages. So oftentimes when we're doing a report, we'll have a section that shows the Medicare covered as well as the non-Medicare covered. Now, I mentioned earlier that drugs make up about 60 to 65% on average the total MSA amount. Why is that important? Because when we're reviewing other Medicare Set-Asides from other firms, the first thing that we look at is the pricing of the drugs, because too often we see that the drugs are priced incorrectly, okay? But per CMS, they want us to use what's called average wholesale pricing, which are pretty high numbers as far as pricing medications are concerned. But what we do and what we're allowed to do is price for generics whenever available. Clearly, generics are going to be much cheaper than having to use AWP pricing. So what is the information that we're going to request from you? You're looking at it. 2 years of the last payouts and prescriptions if they're available. The last 1 to 2 years, medical records. If you have the last 3 to 5 years, that works too. But we're really going to look at the most recent records. Rated age, I talked about that. So how do we get the rated age? So we oftentimes submit medical records to the annuity companies, the life insurance companies that underwrite structured settlements. We have clients that are either doing a structured settlement or Medicare Set-Aside, and they have independent underwriters that assign these rated ages, and that's what we use. We have to use the median rated age, typically for workers' comp and liability. We have more flexibility to possibly use the highest rated age to get the lowest number, because there's no strict formula as in liability as there is in comp. So the other method that we use, there is one independent medical underwriter that's CMS approved. And as an alternative to submitting for rate age to life insurance companies, we can use that independent underwriter who oftentimes will give us the best rated age, which leads to the lowest number ultimately. HIPAA release, obviously we got to be HIPAA compliant and making sure that everything we do is compliant with HIPAA. Key components. If you're looking at one of our reports, all this information is going to look very similar to a life care plan, but almost like a hybrid, shortened version of a life care plan. As far as the demographic information, we put in there if the client's eligible for Medicare benefits at the time, when they're going to be eligible for Medicare benefits, what are the costs of the Medicare allowables, annuity funding, how is the MSA going to be funded. We put parameters in there of how the MSA can potentially be funded with an annuity versus lump sum funding, which we'll talk about. We also talk about administration. And with our MSA reports, we include a self-administration waiver and a letter to both the attorney and the clients that gives them very strict directives of what best practices are, okay? It also provides a self-administration waiver, so if the client elects to set aside their own money and do it themselves, well, they've signed off on something that says they understand. Now, do they understand when they sign off on that thing? Probably most of the time, no. But it's a very thorough analysis and very thorough review of what they should be doing that we include with our reports. Rated age, we talked about, past treatment history, current treatment, prognosis for recovery, ICD codes, life care plan. So ICD codes are critical. We're going to hammer that today as we go through this. There are over 140,000 different ICD codes. What we don't want to happen is the wrong ICD codes. Obviously, we don't want the wrong ICD codes to get reported. But as a fact checker, we'll put the right ICD codes in the Medicare Set-Aside analysis. So if there's ever a discrepancy, you check the facts, and the facts being our Medicare Set-Aside report, our ICD codes are only going to include what's necessary and obviously related to the accident. So what does that actually mean from your standpoint? When should we get involved? I get that question a lot. So the earlier the better. And I want to say that for all of our services, whether it be us getting involved to handle a catastrophic mediation with a structured settlement, or with a trust, or with attorney fee deferrals, or with lien resolution, or with Medicare Set-Asides. The earlier we can get involved in the process, the better. I've been in mediation too many times where we're sitting around a table, you've negotiated a phenomenal settlement for your client, and the client says, oh, I got my Medicare card last week. Oh, by the way, I used it. And next thing you know, we're scrambling because you got a client who thought they were getting X amount of dollars in their pocket. You thought you had a full settlement, and now we're rushing to come up with ways to address the issue. That we don't want to happen. And some of you on this conference have had that happen to them, unfortunately. Identifying potential Medicare beneficiaries. God bless our clients. Most of them don't know what they have, whether it be Medicare, Medicaid, Medicare Advantage plans. Over a third of the population right now has Medicare Advantage plans. Okay, there's a lot of case law coming out on Medicare Advantage plans. You've got to fact check whether or not your client's on Medicare Advantage plans. I can tell you unequivocally that over a span of, again, many cases over the years, I have never seen a Medicare Advantage plan deny something post-settlement, assuming their lien has been paid back, ever. Now, is that going to change going forward? Medicare has told us, look, we're sharing what's called the common working file, which I mentioned, with our Medicare Advantage partners, meaning they potentially have access and the same ability to deny something if they get a benefit and they tie it back to the claim, because arguably they're saying they have the same rights of recovery as traditional Medicare. I will send you that as a takeaway, that document that you can add to your intake process. Immediately get that filled out by your client, identifying what their potential benefits can be. You can do that on their behalf, or you can have them go down to their local social care office and do it themselves. Here's a little acronym for Synergy: Start early, identifying Medicare beneficiaries, control the MSP process from start to finish. You can't rely on opposing experts, okay? You would never rely on opposing experts' life care plan to settle your case. You shouldn't rely on opposing experts' Medicare set-aside either. Educate your clients on the potential risks of not doing anything, retain your own experts to protect your firm, and go on the offensive on all these issues, especially Part C Medicare Advantage Plan, liens potentially. And then document your file. Regardless of what you do, you want to make sure that your file is documented. That's all we have on Medicare. So now we're going to go on to the next presentation, which is going to talk about funding a Medicare set-aside. Okay. So now you've gone through the process. You've engaged an expert to do a Medicare set-aside. We've been working back and forth diligently to come up with a reasonable good faith estimate. I want to stress that. A Medicare set-aside is simply that, a good faith estimate based on all the facts of the case that we have at the time of the settlement. So from Medicare's standpoint, if nothing is set aside, okay, and we were involved in a case years ago where Medicare said the whole settlement is the Medicare set-aside. Over a $2 million settlement where we got involved after the fact because we had to salvage the case. We had to go back to Medicare and say, you're crazy. The whole settlement is not the Medicare set-aside. But from Medicare's standpoint, in theory, if nothing is set aside, they can make the argument that everything is a set-aside. And that's why it's important to look at all the facts and come up with a good faith estimate, whether it be arbitrarily yourself, whether it be the client doing it, or whether it be an expert doing it for you. So now you're cutting the checks to your client. What are the ways we can actually fund a Medicare set-aside? Some quick key takeaways. Medicare allows us to fund a Medicare set-aside with a structured settlement annuity. And a structured settlement annuity is great for a lot of reasons. Or they allow you to use a lump sum. So let's say you have an example of a $100,000 Medicare set-aside. You can fully fund that $100,000 Medicare set-aside, or you can purchase a structured settlement in combination with seed money that will pay out the $100,000 over some time period of life expectancy. So the easiest way to sum all this up on the funding piece of it is that it's much cheaper to fund a structured settlement annuity MSA versus a lump sum MSA, which we'll cover a few examples here. So with the structured settlement annuity, there's annual payments that are made every single year. And instead of that client having to exhaust the full corpus of the MSA, whatever that amount is, over their life expectancy, which could potentially be a long time, they can spend down that money in any single year. And it's almost like an annual deductible in that situation where as soon as they exhaust, if they exhaust, guess what? Medicare's on the tab again. So a lump sum is clearly more expensive. It's more money it's costing your client. It takes longer to expend the money. Now, how do we calculate and determine the parameters for funding an annuity with a structured settlement? I want to make one comment about lump sum funding. The lump sum funding, and also in conjunction with the fee schedule, if our clients are using the money correctly and using it the right way and spending at the cash negotiated price they can get with their providers, they're going to spend that money down at a faster clip. Meaning, even though they're paying a higher rate potentially, if they're opting to spend the money directly and proactively, they're going to be potentially depleting that account much sooner and therefore back on Medicare's tab again quicker. With a structured settlement, there's the seed money, which is typically the 2 years worth of the expected needs of the client, also includes all the large surgeries and big ticket items. So it's broken down. At the time of the settlement, they would take this seed money, whatever that number is to be calculated, and open up that account, that interest-bearing account. The requirements are it has to be separate interest-bearing account, and use that seed money to get the account going. And then approximately 1 year from the time of settlement, the annuity starts to kick in and pay into that account. So with a structured settlement annuity, typically what happens, as we've seen and talked about already, is that they're exhausting a lot quicker. A structured settlement can also be used to fund professional administration, which is nice. Some standalone benefits of a structured settlement, I want to talk about those. They're tax-free. They're typically guaranteed fixed payments for our clients. They're secured with the largest life insurance companies out there. And one of the roles that we as experts at Synergy do is make sure to hold the feet to the fire of the insurance companies if they're offering a structured settlement in any negotiation, whether it be for an MSA or other, to make sure that your client is getting the best payout. And there's no fee for us to get involved for that. And again, a structured settlement can be a great settlement mechanism for your client, and oftentimes the foundation of a bigger settlement plan. But it's also protected from creditors and judgment. So if, God forbid, someone try to sue your client, it's protected from that as well. So in workers' comp, we handle a lot of workers' comp cases, and we handle probably more catastrophic workers' comp cases than anyone in the country. But typically, when comp cases are being negotiated, the carrier will offer to fund what's called a temporary life annuity. And a temporary life annuity sounds exactly like it is, meaning it's temporary. It's usually for the person's life expectancy or upon death. So let's say a person has life expectancy of 15 years, it's either going to pay out for 15 straight years, or if that person dies in year 3, guess what? The annuity company gets the benefit of that windfall. It stops. And that makes this the cheapest option. So a lot of the clients, believe it or not, elect to do an annuity that's not guaranteed because they know they're going to get more upfront cash and not have to allocate so much money to fund an MSA. Now, the flip side of that is we've had situations where our clients have died. Real life example, literally 2 days ago, workers' comp plaintiff attorney called me and said, Josh, I settled this case, and before the ink dried on the paper, before the client could even sign the release, he died. And he settled the case on an expedited basis because the client called him up and said, I'm dying here. And they got the case settled. And I said, well, is there guaranteed annuity? Is there non-guaranteed annuity? Unfortunately, in this situation with annuities, you have 10 days from the time the contract's issued to cancel that annuity contract. And in that scenario, the contract had not been issued yet. So the plaintiff's family was able to get the benefit of the premium or the cost to fund that annuity, thankfully. But we've had a case, if we're doing structured settlements and funding temporary life annuities, we always have what's called a guarantee waiver signed by the client so that they understand that, look, even though we're getting the cheapest option here, if something happens to me, my family's not going to get it. Temporary life with premium simply means they're going to get their money back. If it's $100,000 cost the annuity, no matter what happens, the annuity will be guaranteed to the family or beneficiary for at least $100,000 worth of a payout. And then life with guarantee payouts are the most expensive. So life with 25 or life with 30-year guarantee simply means it's like a paycheck that someone can outlive. Same goes for option 2. Option 3 is that person lives, and 2 and 3 both. If that person lives to 125, guess what? That annuity is going to pay them to 125. But if they die, in year 5, the payments are still guaranteed for some time frame, whether it be 25 years or 30 years at least. And oh, by the way, if they die, the money's tax-free to their family as well. I'm just going to fly to this slide just to get us caught up on time. This is part of the presentation of slides, which you can go and look back and see the comparison. Here's a brief example, a real case of a quad where we had an MSA of $227,000 and change, and ultimately, when you looked at the cost to seed and fund that annuity MSA, the cost came down by about 40%. Tremendous savings for the client, and they're in compliance with CMS. The third option for funding is not funding the MSA. We have a lot of clients that opt to self-administer, and they say, I don't know what I'm going to do. Or they agree to fund an MSA, and then they spend the money on something else. This is a swimming pool. Unfortunately, I had a case years ago where it was a workers' comp case where there was an MSA involved, and he settled his case, and this particular gentleman moved to Costa Rica. He sent me a postcard and said, Josh, how do you like my Medicare set-aside? He went out and purchased a pool, brand new pool, nice pool, with his Medicare set-aside money. If that ever happens, these are, that's going to be big issues for Medicare. And that's typically the bigger issue. When I say the bigger issue of not are we setting aside enough money, but rather are the funds being spent appropriately in the set-aside account? And Jason's going to talk more about administration. Cars, we have clients that have bought cars. We have clients that have bought horses. We've seen it all, unfortunately. But as trial attorneys, all you can do is make sure that you document your file. What is being done is what your clients agreed upon. If it's going to be a self-administered MSA account, it's on the client at that point whether or not how they're going to spend the money from the MSA. I want to shift gears briefly to what we're seeing on the defense side as far as their position on Medicare set-asides, and in particular liability Medicare set-asides. Jason talked a little bit about this, but what we're seeing on these catastrophic cases, even non-catastrophic cases, the cases I call bread and butter cases, the cases that keep the lights on, is that you're getting a release typically at the 11th hour that's got 6 pages of Medicare release language, and oh, by the way, they want your client to fund a Medicare set-aside. Oh, and by the way, they want you to submit it for CMS approval, which right now in liability cases, 99.9% of the time they're not even reviewing. It's a voluntary process. But we've also seen ultimatums where they say, okay, here are your options. You can do a fully funded Medicare set-aside. And we've had to actually go before judges multiple times to show the judge that we need to argue for a lower set-aside amount based on all the facts of the case. And we've had to do that many times. And that's a last resort. You don't ever want to get to a situation where you have to go before a judge or try to get a motion to enforce the settlement because the carrier is refusing to bend on the Medicare set-aside issue. That's why it's important to address it early on in the mediation agreement. Okay, but we've had to do that. I've served as an expert. Jason served as an expert on that issue. It's a last resort, but it is a resort. CMS has said they will honor a judge's ruling on the merits of the case. And the third thing we've seen happen as an option is that they say, look, here, sign this waiver that they're not ever going to bill Medicare for anything. Okay. Recently, we had a situation where an attorney called us after the case settled, and those were the 3 options. And there was a 4th option that wasn't even an option that was satisfiable. And he agreed to those terms and ultimately had to tell the defendant, I'm going to get a motion to enforce the settlement because we went to them with a Medicare set-aside. They didn't agree with it. We had them sign a waiver, didn't agree with it. And finally, we held their feet to the fire, and they caved ultimately. But he had to really hold their feet to the fire. The problem with this, there's not a one-size-fits-all approach. Okay, there's things on liability cases such as caps on damages, liability issues, coverage issues, pre-existing conditions. All these things have to be taken into account, especially in liability cases. And workers' comp, it's a no-fault system. It is what it is, and I hate that expression, but it's very straightforward because the medicals are very straightforward as far as calculating what the numbers are. It's never straightforward in liability. It's always gray somewhere along the lines. But we use that to our advantage to come up with the lowest possible and justifiable MSA that we can come up with. But a Medicare set-aside is not the end-all be-all. It really isn't. The fundamental question that you have to ask yourself as a trial attorney, by settling this case, am I shifting the burden to Medicare to pay? Am I shifting that burden to the trust fund to eventually pay for my client's treatment? And there are a lot of situations where that's not the case. And going back to that litmus test, if one of those 3 criteria isn't met, we can actually put together what's called a no MSA letter for your file for $500. It says, based on all the facts of this case, there's no need to do a Medicare set-aside. And as Jason mentioned, it takes oftentimes a legal analysis to get there. But just some quick alternatives to doing a traditional Medicare set-aside. We have a lot of clients that have access to traditional forms of health insurance, whether it be through a spouse or whether it be through a governmental job. There are some private health insurance benefits that last for as long as the client's alive as part of their fringe benefits package. There are situations, though, where a client may lose that health insurance. And if they do lose that health insurance, they're going to be back on Medicare's tab. But as long as they maintain that private health insurance, practically speaking, it's never going to be an issue. So from Medicare's standpoint, they've told us in their workers' comp reference guide that they don't care if there's other health insurance, and which is wrong because Medicare doesn't live in the real world. They live in the theory world. And from a theory standpoint, they don't care if someone has private health insurance. They still say, look, our interests have to be considered, our future interests. Plaintiff can pay out of pocket as they go for treatment. Some of our clients say, Josh, you know what? I'm not going to set aside any money, but if I have to treat, I'm just going to agree to pay it. And I'm going to negotiate with my doctors, try to get the lowest price I can get, and go do it that way. In that situation, guess what? There's no shift to Medicare to pay. The problem with that is if the treatment gets worse over time, the client may end up spending a heck of a lot more money rather than they just set aside a good faith estimate on the front end. But it is still an option nonetheless. Medical savings account. This takes a certain criteria to get into those, but we have those done frequently as well. Settlement preservation trust. My partner, Jason Lazarus, who also just had a catastrophic injury about a year ago, and he recently set up a settlement preservation trust. I hope I'm not breaking confidence by saying this, but it's earmarked specifically for health insurance needs, okay? We have a lot of clients that are doing that, saying, Josh, you know what? I'm going to set up a trust. I'm going to have a professional trustee, and we're going to designate a pot of money to be paid out, whether it be through a structured settlement into the trust and out for medicals, or just a cash flow of money that comes out of that trust to be used for future medicals. Again, in that situation, there's no shift. Finally, structured settlement is a great way and a great alternative to protect the trust fund. Oftentimes, as a split the difference scenario, to get the case to the finish line, we'll set up a structured settlement for our clients to be designated to be used for future medicals. Oftentimes, this works great when you have a case where there's a workers' comp component and a liability component. So oftentimes, the liability case will settle and the workers' comp claim will remain open, especially on catastrophic, 7-figure, 8-figure cases. A lot of times they don't want to settle the medical and the comp. It stays open. But in liability, they're then on the hook in most states to pay a percentage of their medical going forward, okay? In those situations, we can set up a structured settlement that can be used to fund that percentage difference in their pocket. Also, if they ever settle their workers' comp case, ultimately an MSA will be done on the comp side. It falls back to the comp side, and then they can use that structured settlement to go right in their pocket for payments to help them for other things. That is it for my presentation. I'm going to swing it back over to Jason. Hope you guys are enjoying this so far. We're getting almost caught up on time.
If you guys have any questions, there is a chat feature that you can utilize and just put the questions in writing since everybody's in just listen-only mode right now. So if you do have questions about anything that we've presented thus far, if you type them in, we'll try to address those questions as we continue along. We're just trying to keep it moving because we know your time is valuable. So Josh talked about the funding mechanisms for set-aside. So the question becomes, what do you do to properly administer a Medicare set-aside? And the answer from CMS is that a Medicare set-aside should be placed in a dedicated, which is segregated from other assets, interest-bearing account. So it can be self-administered if allowed by state law, or it can be professionally administered with a Medicare set-aside trust. So in terms of how you determine how those funds are utilized, it's pretty simple. It's basically that the funds can only be used for Medicare-covered expenses that are injury-related or Medicare-covered prescription drug costs that are related to the underlying injury. And once the amount that's been set aside has been exhausted in proper notification to CMS, the Medicare should be billed for remaining covered services and prescription drugs, even if they're related to the injury. So CMS has a few, what we put in quotations, regulations related to administration. Say regulations in quotes because it isn't a situation where you've got law. It's policy memorandums that CMS has come out with over the years, which outlines different aspects of Medicare Secondary Payer Act issues related to set-asides. So this area is not really truly regulated by law, but it does have some questions and answers that are relevant, which talks about, one, that the monies have to be an interest-bearing account. If there's a representative payee, a guardian, a conservator, or someone that's incompetent, then the Medicare set-aside arrangement, if it's submitted to CMS, should indicate such. And that is a situation where under state law, by default, the person could not self-administer. So if there is a professional administrator or someone self-administering, they are supposed to forward annual accounting summaries concerning the expenditures out of the set-aside to CMS. So that is a way of them monitoring to make sure that payments have been properly expended on Medicare covered services and at the correct rate, because it has to be paid out at the proper rate. And one important note is that administrative fees, expenses, attorney's fees associated with establishing the MSA cannot come from the set-aside arrangement. It has to be from funds that are outside of the amount of the set-aside. So say the set-aside was $100,000, if the administrative expenses to create a trust and administration were $3,000, that $3,000 would have to be paid separate and apart from the $100,000 used to fund the set-aside. So the question is, when should you consider professional administration and why? Typically speaking, it's going to be in one of two scenarios: a larger dollar MSA or a unsophisticated client who simply can't do the accounting and can't figure out what Medicare rates should be used. Actually, not Medicare rates, fee schedule or usual and customary rate should be used to pay that provider. So those are really the two scenarios where you start to look at whether professional administration makes sense. In terms of the benefits for the Medicare beneficiary, they've got an expert to negotiate the cost of future medical services if they hire a professional administrator, and they are making sure that their Medicare benefits don't get interrupted or delayed because of administrative issues of the set-aside. And in terms of your perspective on it, you know, if professional administration is used, it basically reduces any potential future exposure, although that's pretty remote. You do know that your client has the highest degree of protection if they have a professional administrator ensuring that they remain eligible for Medicare, and make sure that there are as little as possible to no errors and omissions in terms of the administration of that set-aside. So Synergy has created a pretty unique and low-cost solution for Medicare set-aside administration, and it's a pooled Medicare set-aside trust. And the benefits of using this type of an arrangement is the client doesn't need an individually drafted trust. Instead, they join an already established master trust, and it provides a professional administration solution that is low cost. In most instances, there's just a one-time fee at inception with no ongoing administrative expenses. The Medicare Set-Aside Pool Trust was established by the Foundation for Those with Special Needs, Inc., which is a 501c3 that we founded that is dedicated to helping those with special needs, and it supports charitable organizations that protect and promote the civil justice system. So by having clients join it, you're also helping protect the civil justice system. TrueLink Financial is the administrator and handles the asset management of the pool trust assets. Then we have a separate administrator that adjudicates all of the bills to make sure that they are a properly Medicare covered expense and are paid out at the proper rate. Optum is a built-in RX and DME provider. So it's got a pretty comprehensive set of services for the client. And one of the advantages of a trust like this is that it goes on in perpetuity. Many set-asides are managed with custodial arrangements, which do work, but the problem is if the custodian happens to go out of business, then their assets could be exposed to creditor claims and judgments and the like, and then you have to find someone else to administer it. Whereas with a trust, if any of the parties fail to serve, a new one would simply be appointed. In terms of the fees, typically it's just a one-time fee at inception, which is based on the allocation amount. It ranges from a low of $750 to a maximum of $5,000, and that is for lifetime expenses. So assuming they have prescription drugs that are part of their allocation of $25,000 or more, there is no annual fee. If there is less than $25,000 in prescription drugs included in the allocation, then there is a small annual fee of $300. So that's all I am going to cover for MSA administration. I'm going to turn it back over to Josh again.
Stay with us, guys. Stay with us. Get some coffee. Just got a big cup of coffee myself. And now we're going to be talking about most recent activity that we've seen. Okay? And we're going to start back in 2016 because this was the first tease that we got from CMS that said, look, we're considering expanding our voluntary review process to include liability MSAs. Okay, I could even go back even further, but I want to stay relatively current. Back in 2014, CMS put something on the table that tried to establish a formal framework for liability MSAs. Started in 2012. Ultimately, they withdrew in 2014, said, you know what, we can't handle this situation. And I'm proud to say, before we go any further, that Synergy has lobbied hard against CMS doing anything like for liability MSAs. We told CMS, look, you can't handle it. You got enough problems on your own when dealing with the conditional payment side. We've worked very closely with trial lawyer organizations, including the AAJ across the country, to really fight CMS on this issue of liability MSAs. So back in 2016, July 2016, almost 2 years to the date of today, we got this announcement. I encourage all of you on this call to sign up for CMS alerts. CMS sent this by way of email. And once that came out in July 2016, things moved rather quickly as far as the activity was concerned on liability MSAs. There was an invite-only roundtable discussion, which AAJ participated in. There were key stakeholders throughout the country, some of the largest insurance companies, self-insured entities, some of the largest corporations. There were about 40 people that participated in that meeting, including head members of some government officials. And I was able to participate in that meeting, fortunately, because I was the chairman of the liability MSA committee for NAMSAP, National Alliance Medicare Set-Aside Professionals. And at that time, the discussion was, is this really going to happen? We heard this before. Is it really going to happen? Nothing going to happen. What's going to happen? What do we do? And it was determined at the outset of that meeting that we were going to go to CMS and say, look, you can't handle it. But our backup option was, if they're not going to hear us or meet with us or meet with any of the key stakeholders, we're going to write to them and say, look, here's how you should do it. And going back to NPRM, National Proposal for Rulemaking, the NPRM. Whoa, I need some more coffee. Notice of Proposed Rulemaking, where they suggested multiple different ways to handle liability MSAs as possibilities. We kind of use that as a framework to go back to them and say, look, here's the problem with those suggestions. And back in 2014, we were one of the only companies and firms in the country that actually provided direct commentary to CMS on the issues. At the time, CMS said, look, we're soliciting feedback from the market. Those of you that are in this space, how do we handle it? And we worked, again, with AAJ and said, look, if you're going to handle it, here's how you do it. Fast forward, we're moving along. The CMS, AAJ makes announcements about CMS that they're going to be bringing new policies potentially on liability MSAs. December 2016 comes around. CMS put out a proposal for a new workers' compensation review contractor. And I want to go back to this in a second. But in that proposal for a new workers' comp review contractor, they specifically mentioned that whoever is going to be the new contractor has to be able to handle liability MSAs. And there would be two different potential tiers of liability MSA reviews. They put that in their proposal. First time we'd ever seen that. And, it got a lot of attention after immediately getting no attention. When it came out, it wasn't a big deal, except for those who were in the Medicare Set-Aside community and MSP professionals. They took notice of this. Fast forward, February 2017, this is when things really got interesting. And we got this announcement that said starting October 1st, 2017, Medicare and their contractors will reject medical claims on the basis that they should be paid from a liability MSA. So when this came out, panic ensued. Our phones were ringing off the hook. We were having 500 people sign up for webinars saying, is this the situation now where we have to do liability MSAs come October 1st, 2017? Well, October 1st, 2017 has come and gone, and we haven't seen a change in anything. And what do I mean by change in anything? We haven't seen really a significant change in Medicare denying anything or refusing to pay for something. The thought process was, and a lot of people incorrectly thought, starting October 1st, 2017, you have to do a liability MSA. Again, nothing could be further from the truth. All that CMS did was issue this alert to the medical community. And that's important to note also, because the medical community is so used to just billing Medicare for everything, right? In the old days, they would just bill Medicare and they get paid back. Whereas now Medicare sent this alert out saying, you know what, guys, going forward, we're going to start to reject these claims potentially. And they also, in that alert, they talked about what a Medicare set-aside is, and they reference the basis for why they would reject a claim going back all the way to the Medicare Secondary Payer law, that they're not to be the primary payer. That's what their reference was. And it's also important to note that Medicare does not have to make any changes to what's happening right now for them to reject a claim or to say we're not going to pay. The Medicare Secondary Payer statute is the authority in that regard, and it hasn't been changed in over 35 years. So if they wanted to turn that faucet on, so to speak, at any time, they potentially could. But my hypothesis, and I know it's not even a hypothesis at this point, is that they can't figure out this apportionment issue. It's really got their minds baffled, and they've told us that. And over the last few years, there's been other meetings happening where we try to tell them and give directives that this is what you need to do as it relates to liability MSAs. So going back to October 2017, we got the same exact message that we got back in July 2016. If you put them side by side, the verbiage is almost identical. Okay, they basically said, look, we're considering expanding our interest to include liability MSAs on review thresholds. Why is that important? So in workers' comp, at the start of this presentation, we talked about review thresholds, where if they meet a certain criteria, number one, client is eligible for Medicare and the case settles for $25,000 or more, or number two, the client is going to be eligible the next 30 months and the case settles for $250,000 or more. If it falls underneath that criteria, Medicare will actually take the time to review and approve a Medicare set-aside. Okay, that's all for workers' comp. It has nothing to do with liability cases. But here they're talking about expanding those review thresholds to potentially include liability MSAs. So what happened in workers' comp, and this is important, okay? As we mentioned, Medicare Set-Asides are not required even in workers' comp. But what's happened in workers' comp over the years, it's morphed into situations where anytime you're settling a case that meets this criteria, most often the carriers are trying to mandate a Medicare Set-Aside be done and then also require CMS approval and their blessing. It's just become the de facto way of settling cases. So even though it's not required, it's just become the standard. And it's early enough in the process of liability cases where hopefully that will not happen. But fast forward again, we talked about that CMS putting out that proposal for a new contractor. So that review contractor is someone that engages with CMS who actually has the entities around the country and the manpower to review those MSAs that are submitted to them. Okay, and they finally awarded a new contract last year. Okay, to this company called Capital Bridge, and the new contract had a value of $60 million. It's important because the last contract was only worth $6 million, nearly a 10x increase in compensation. And many people seem to believe that is because liability MSAs are going to be on the table very soon. And what's happened since this new contractor has taken effect, number one, I've gotten an influx of resumes of nurses and contractors that want to work for Synergy. But number two, I know firsthand from insider knowledge of people that are on the inside working there that it's been an unmitigated disaster so far with this new contractor. And sometimes CMS pops in on these presentations that we do, but unfortunately that's what I'm hearing firsthand is that they're way back behind as far as approval of workers' comp MSAs because this new contractor had no experience dealing with MSAs, and it makes sense that they'd struggle. So I say all that because they're backed up, they're struggling. There may be a push for them to get pushed out for a new contractor. I don't know if that would ever happen or if it could happen at this rate. But liability MSAs, although they're making inroads that they're threatening, I call it a threat because we've seen this before. This threat that liability MSAs are coming in the form of formal guidelines, but nothing may happen. We just have to see how things shake out. You know, in the old days, when you settled a case again, you never had to worry about, a contractor or Medicare Set-Asides or denials. You had the safety net that everything was going to be taken care of. So more recently, there's been some private meetings with CMS, and I can't talk about those, but I know they've had some here in the last 3 to 4 months, with stakeholders, key stakeholders, where they've solicited feedback again. And going back to 2017, when they said they were going to solicit feedback from stakeholders, they've now been doing that, but they've been doing that very hush-hush under the radar with special invites. And I would hope that they would solicit the open marketplace to get the trial lawyer's perspective. AAJ, I know, is involved, working very closely and trying to get involved and push CMS as well. But we don't know yet what's the outcome of those meetings. We don't know. So I also want to talk very, very briefly. There was a new recovery contract that was awarded also in October 2017, where this new contractor goes after payments that they shouldn't have made. And they issue a report every single year, Medicare, on payments that shouldn't have been made. And the sole purpose of this contractor is to go after payments that they shouldn't have made. And sometimes Medicare makes mistakes and they pay for things when they shouldn't have. And this new contractor is completely different. It's a different entity, and they have a different task, which is tracking down payments that they shouldn't have made. Whereas the other contractor, the workers' comp review contractor, is potentially in the role of actually having to review and approve MSAs and establish the legal framework for MSAs on the liability side. So what's actually going to happen? We've been hearing this for so many years, and that formal guidelines are coming to liability cases, and nothing's happened. If anything, there's been more awareness. CMS is very good at stirring the pot and making people aware that this issue is on the forefront of their concerns, allegedly. But as again, as far as denials and Medicare coming back and saying we shouldn't have paid, maybe nothing happens. Maybe it's status quo. Maybe there's still the random denial or the random look back where they couldn't try to collect money when they should have. But we don't know. Another option potentially could happen is CMS actually introduces by way of a policy memorandum that says, look, we're going to open up the submission threshold to include liability cases. And if that happens, again, we talked about in workers' comp where the floodgates could really open up, where this becomes a serious issue that you as trial attorneys are having to deal with on every single case, whether you like it or not, unfortunately. And it's already starting to happen, I hate to say it, where you're getting calls, you're getting inquiries from the defense to do things or not do things or agree to certain language, and it just slows down your case, ultimately. And it costs you more money, it costs your client more money. That's why it's key to get folks like us involved. Even if we're not going to ever do a formal MSA or work on a lien for you or set up a trust or structure or anything like that, a lot of what we do all day, every day is just fielding phone calls. A big part of all partners in this firm, all the way down to the bottom line of people, is answering questions and helping provide guidance at no charge all day, every day. The other thing we may potentially see happen is we start to see an actual frequency of denials. That has not happened, as I've said, but it could happen. My prediction is that towards the end of this year, and early part of next year, you may start to hear or see more denials. I hope that's not the case, but I think you're going to start to see that. Another thing that was talked about was that CMS was thinking about issuing a reference guide. So in workers' comp, they have this reference guide, a workers' comp MSA reference guide that's like the Bible for workers' comp MSAs and provides a framework. And that's something else we could potentially see going forward. So just something to think about. And then as Dave is going to talk about on the Medicare Advantage Plan side, that I hate to say it, but I think there's going to be a situation involving a Medicare Advantage provider where they're going to try to bring a lawsuit against somebody on the future's interest. Hasn't happened yet, but I hate to say and speculate, but I think it may happen. So next steps for you guys is really to develop those internal practices for your firm to really safeguard your firm from the start of the case to the end of the case. And a lot of you may already have programs like that. If you don't, we can help you put those programs together where you're auditing every single one of your files that come in the door. So there's no surprises, there's no guesswork. A lot of what we do is training. We're happy to come to your office, provide a nice meal for your clients, your family, your employees, your staff, your attorneys, and train them on these issues so they can, again, be aware of what to look for and how to handle these cases. And I want to reiterate that you should all sign up for CMS alerts to stay informed on all these issues. And then if you want to refer us to any cases, here's a link to refer us to any type of cases. But the last thing on the CLE training is all that's complimentary. We're happy to do that at no charge. I'm now going to pass it back to Jason again, and soon we'll be into conditional payments.
Well, as the CEO of the company, one thing I would say is that while we do quite a bit of free consultations, our preference is to get paid since we are a for-profit company. But we do, as Josh said, do quite a bit of consultations free of charge. We certainly do a lot of analysis of liens to determine whether it makes sense to outsource it to us, or consults regarding Medicare compliance, or whether a trust is necessary for a Medicaid beneficiary. So certainly we do that quite a bit of the time, and we are always happy to help you guys troubleshoot and figure out whether you really need us or not. Because one of the things that we do pretty firmly believe in is only getting involved in cases where we can make a difference in the person's life. And that really is our mission at Synergy, is improving people's lives. We talk about that with our staff continuously, and the way even our lien resolution group team members are compensated. They're compensated based on how much they save the client. They are bonus based on that, so they are encouraged to do the best they possibly can for our clients. So that's our mission, and that's our promise to you guys that decide to work with us. So now I'm going to talk about dual eligibility, which is a small part of the injury victim population, but it is an important area to have a basic understanding of for you as the practitioner, so you know what to do when you do wind up with a client who has both Medicaid and Medicare eligibility. So somebody that is dual eligible means that they've got Part A and Part B as well as Medicaid. And so the Medicaid programs are complementary or pay for things that Medicare doesn't cover in these scenarios. So if somebody has the top level of coverage, then Medicaid will pay Part A and Part B premiums, deductibles, and copays within prescribed limits and extra help with Part D expenses. So basically, the client has no out-of-pocket if they are in a dual eligible scenario like this. So it's very well worth preserving when you come across a client that does have eligibility across both of these programs. One thing to note, though, is that in these scenarios, Medicare is actually primary over Medicaid. So Medicaid is really the program of last resort. So if you've got a client who a Medicare set-aside is going to be established for, and they are also eligible for Medicaid, then the MSA is an available resource for purposes of calculating eligibility for Medicaid and SSI. Medicaid and SSI are needs-based benefits. SSI has an asset threshold, asset cap of $2,000 if you're single or $3,000 if you're married. And most Medicaid programs use that same threshold because there's a automatic eligibility in most states. If you get $1 of SSI, you automatically get Medicaid. So that's why this can become particularly problematic if you've got someone that's dual eligible. So in order to keep the dual eligibility intact, if a Medicare set-aside is done, then it's done inside of a special needs trust wrapper. And all an MSA S&T is just an S&T with MSA language. Now, there are cases, and I frequently advise clients about this in my law practice here in Florida, where I do quite a bit of special needs trust in my elder law practice. I will counsel clients about whether it makes sense to have a separate and distinct set-aside. Typically, it makes sense in larger set-asides because if it's a small enough amount, it simply can just be part of the S&T, and the S&T is the set-aside. So if Medicare ever denied care, the S&T would simply pay for those Medicare-covered expenses. But in cases where there really is a need for a separate and segregated set-aside, that's when the MSA hybrid S&T trust makes sense. So in those scenarios, we do wind up having two separate trusts. We will have a special needs trust, and then we'll have a hybrid special needs trust MSA. And you wind up having a setup that's like the MSA trust that I talked about in our administrative presentation. Now, there is some increased expense because you have two trusts, but in cases where there's a larger recovery or catastrophic cases, it makes sense to incur that extra expense. So we have created a separate trust for clients who are Medicaid eligible. So this is different from the trust I talked about earlier when I was talking about professional admin, because this is the hybrid special needs trust Medicare set-aside. The other trust I talked about was only for people that are exclusively on Medicare, not those that are dual eligible. So this trust, like the other, is a master trust that people join, so they don't need to create a individually crafted trust. Instead, they just join an existing trust. It's not complicated. And the fee structure is identical to the one that I talked about. Same exact benefits and services that you get. from the other trust. So it's a pretty turnkey solution for clients that are dual eligible. And in addition, there's a SSNPT, which is an acronym for Settlement Solutions National Pooled Trust. There is a sub-account that the client can use for their non-MSA funds. So basically they have two different sub-accounts in the two different pooled special needs trusts. So that's it for dual eligibility. Not all that complicated in terms of the subject matter, but those clients definitely need more comprehensive and complicated planning, and that's part of our expertise at Synergy. So with that, I'm going to turn it over to Michael Walrath, who is going to talk about hospital liens. So at this point, we're going to transition into a part of the presentation that is focusing more on lien resolution as opposed to the Medicare Secondary Payer Act. So if you'll give us one moment, we'll get it swapped over to Michael as presenter.
Hello.
So Michael, who is now the presenter, I just want to give a brief introduction about Michael. Michael Walrath is an attorney like myself, is a renowned specialist in hospital billing and coding and resolution of hospital liens. And because there's been some more recent chatter about Medicare and hospital liens, we're including him in the presentation today to talk about that interaction. And because of his knowledge and expertise, we're really glad that he could join and be a presenter as part of today's webinar. So with that, I will turn it over to Michael.
Thanks very much, Jason, and welcome everyone. I guess it's getting late in the afternoon. Can you hear me? Okay.
We can hear you.
Good. It's getting a little later in the afternoon, so I'll go through this relatively quickly. Thank you for the introduction, Jason. There has been some interesting developments, more of a reaffirmation of a development a while ago with regards to Medicare as it relates to hospital liens. And that has to do with what happens when a hospital refuses to bill Medicare. Many questions I get are they really allowed to do that? And the answer in most states is absolutely yes. Under the Secondary Payer Act, Medicare is not supposed to be primary if there is another source of coverage, and your liability settlements, unfortunately, are that other source of coverage when it comes to this question. So Medicare the hospital can choose whether or not to bill Medicare for the care rendered to a Medicare beneficiary. But there was some guidance back in, I believe 2009 was the first time it came out, and it was just reissued, I think it was last year, where Medicare interpreted its own rules to state that hospital liens can be pursued instead of billing Medicare. However, those hospital liens would expire the same as the timely filing period does, 1 year from the date of discharge. And the most recent guidance was crystal clear that from Medicare's perspective, a hospital lien has to be released 1 year from the date of discharge. And at that point, there would be no ability for the hospital to bill Medicare because their window has closed, and there would be no way for them to bill a beneficiary or bill that beneficiary settlement. So when the hospital chooses to stand on those lien rights, they only have a year to do so. And most importantly, and this will sort of transition into the rest of my presentation, they don't somehow have a right to a lien for whatever amount they say or their full bill charges. Instead, they have a lien for the reasonable amount of care in most states. So that gets me to what everyone does now, or at least most of the folks I speak with regards to figuring out how to negotiate that hospital lien. And the answer, unfortunately, is most of the times us plaintiffs' lawyers are only able to do what I would call a blind negotiation, basically asking for a discount from a full bill charge as if that full bill charge is the amount that's actually owed. And the truth is, under the law in almost every state, there are a few exceptions, but in almost every state, the law is the same. Only a reasonable amount is due to a hospital, regardless of what their full bill charges are. And if you're negotiating down from this hospital's, made up full bill charge number, you oftentimes will settle for whatever the best discount you can get is. And I see 20 and 30% pretty regularly. And I don't recommend to anyone that 20 or 30% off of a hospital lien is a good deal. I think that's overpaying significantly, and we'll get into why in a moment. One of the solutions that Synergy has to this problem, and by problem I'm referring to the fact that you're in somewhat of an informational vacuum, is we're now offering a report which actually calculates the cost of care from the hospital's own self-reported cost data that they've submitted to Medicare. Another connection to today's presentation. Every hospital in the state that receives Medicare has an obligation under federal law to submit what's called a hospital cost report every year. That report details the actual cost and charge information for every revenue center at the hospital and gives, at the end of the story, basically the ability to calculate a cost to charge ratio for each of those departments. And the reason this is important is it allowed us to build a database where we can take a hospital bill from any hospital in the country, pretty much, because very few hospitals are not Medicare recipients. And we can take a bill for your client and tell you in that hospital's own sworn statement, how much did it cost them to render that care to your patient? That report would allow you to define the reasonable value supported by the hospital's own data and to negotiate up from that reasonable value instead of down from the hospital's full bill charges, which I like to call inverting the argument. I took a case study that we recently did. It was a hospital bill of $95,000 or so, and I wanted to use that to illustrate the difference in these two approaches. The first approach is what this slide depicts, is negotiating for a discount off of that full bill charge. And if you were to get a 20% discount, you get it down to $76,000 or so, you're still giving the hospital almost 650% profit above their cost. A 30% discount, still 420% profit, 420% their cost as their profit. And even if you negotiate a 40% discount off of that $95,000 bill, you're still giving the hospital almost a 350% profit above their costs, which I just say is too much, especially in these cases where that's the only money your client's going to see. So if you consider that same case study, the same $95,000 bill, our report came back with a reasonable value on this particular bill of about $20,000. If you were to negotiate up from that cost, well, actually, it's not even just from the cost, because our report, when it says a reasonable value, and I'll get to this in a little more detail in a moment, we don't equate cost to reasonable value. We say reasonable value is some reasonable percentage profit above cost. So the reasonable value in this bill, including that reasonable profit, was approximately $20,000, and 25% above that, if you were to work up, would equate to a 74% discount. Now, that's a good discount. If you were to offer the hospital 50% more than the reasonable value of their care, which, remember, is all they're entitled to under the common law and under the actual statutes, lien statutes in most states, you would have negotiated a 70% discount from the full bill charge. And if you offer them 100% more, you actually give them twice what they're legally entitled to, you've still negotiated nearly a 60% discount from the full bill charge. As you can see, that's dramatically better than negotiating down from full bill charges. The reports are priced as follows. If you look at the same bill, $95,000, let's assume that the hospital has offered you a 30% discount before you purchase a report. Synergy doesn't charge your client or charge you for savings that you obtained. We only charge for additional savings, a percentage of additional savings. So this $66,000 that you see on the screen here represents a 30% discount offered to you prior to engaging Synergy. Now, our report resulted as I said, in a $20,000 reasonable value, let's assume the hospital accepts 50% above that reasonable value, $30,000. In that scenario, we have created an additional savings of $36,000, which would make our fee about $3,600. We charge 10% of the savings that are actually obtained, the additional savings that are actually obtained. And then when you add that fee back in, you can see here that using Synergy, even after you did your best and got a 30% discount for your client prior to engaging us, would yield an additional net savings of $33,000 to your client. I think that's a win-win, so to speak. The reports themselves basically contain all the ammunition you need to negotiate the very same way that Synergy would. Now, I'll point out that while I'm focusing on reports, Synergy also, of course, is happy to handle the negotiations ourselves. But this report gives you the ammunition to handle them in-house if you prefer. And in some states, there is a preference one way or the other. It really is a matter of preference and a matter of ethical, challenges that some states have put in the way of that decision. So the ammunition it gives you is that our reports identify and remove all of the billing errors and non-billable charges, first and foremost. We don't reprice stuff that should be zero to a reasonable value. Zero is zero. After those errors and non-billable charges are removed, we then calculate the hospital's cost of care for your client's specific itemized bill. We add a reasonable profit of 50% above cost, which is quite generous. There are a number of experts who've testified before Congress and in individual cases, but most notably before Congress numerous times, that have said that a reasonable profit for a hospital is somewhere between 40 and 50% above their costs. And so that's why we use this number to calculate our opinion of the reasonable value of care rendered based on that hospital's own sworn cost data. So these reports effectively level the playing field for you so that you can stop relying on these illusory made up full bill charges as the only data that you have access to. So to conclude, our reasonableness reports are always a savings. If there's no savings, then there's no fee. And even your advance fees are returned in that instance. So in essence, it is a no-brainer and a free roll, so to speak. I guess as a rule of thumb, I would tell you that I never recommend accepting an offer without checking with us. And as was brought up a couple of times, getting a phone call and asking to run through a scenario on a specific lien is absolutely something I do all day long. I'm happy to do from any attorneys in the country. And pretty quickly you tell me what the bill is and what kind of offer you got. I can tell you what I think our additional savings could potentially be, either if you used us to negotiate from there or if you got a report from there, because in either event, we don't charge you for the savings you already obtained. We only charge a small percentage of additional savings that we assist in procuring. And of course, these costs and fees are always passed along, so to speak. The client agrees expressly in advance to purchase these services, whether they be reports or outsourced negotiation. We make sure to have compliant agreements in place so that the client isn't surprised by these extra costs. And the net effect of that is these services, which can only benefit your clients, they cannot result in a cost if there's not a much greater savings than that cost, also are at no cost to the firm. So the firm doesn't pay for these services. This kind of onerous task that comes up by definition after you've already prevailed and settled your case is taken off your plate. And we not only do this service for you at no charge to the firm, we also do it in a way that is absolutely certain that no charges will befall the client except for this small percentage of actual savings, which means that we are always a savings and never a real expense to the client. So again, I just want to invite everybody who has any interest in discussing this any further to give me a call anytime you'd like. I'm happy to go through these bills with you. I'm happy to send you sample reports. If you have interest in taking a look at a report, happy to send you one. Also have some memorandums of law in quite a few states. I wish I could say I had it in all of them. It's been a long process in trying to get up to speed on actual memorandums, but we do have good memorandums in a bunch of states, and we hope to be able to help you all when you run into these problems. So thanks so much, and I'm gonna go ahead and send it back over to Synergy in Orlando.
Thanks, Michael. So the next presentation is by David Place. Dave is a lawyer, again, like me. He spent 15 years on the dark side recovering for ERISA recovery contractors and other plans. And so he has some unique dark side knowledge that he imparts, and also his knowledge and experience with the Medicare Secondary Payer Act, as well as ERISA, FEBA plans, military liens, is unmatched in the industry. And the way he runs our lien resolution group is as an aggressive negotiator. They don't lay down. They negotiate these things hard and rough. The recovery contractors don't like us because of how hard we advocate on behalf of our clients, because that's our mission, is to protect our clients and do the best we possibly can to make sure that they are getting what they should get, and ultimately out of the settlement proceeds, and that these lien holders are getting the least possible bite at the apple, so to speak. So we're lucky to have Dave join us, and I'll let Dave take it away.
Thanks, Jason. I think two things to jump out from the introduction. One, Jason said we fight liens. That is what we do. We're on the plaintiff side. Myself and my team is made up of people from the insurance recovery side, from Rawlings, from Equion, from Gibson and Sharp, who's my firm for 15 years. So we are dyed in the wool now on the plaintiff side. We feel like we got a reprieve from serving the evil empires who are really wanting to help your injury victim clients as much as possible. What we're going to talk about now, though, I think was what Michael said, the onerous processes that are required to deal with lien resolution. And in particular, top of the most onerous list is Medicare. So I'll walk you through the step-by-step process of dealing with a Medicare conditional payment. The reality is that these issues affect not just your client, but you directly. You are personally liable to Medicare Advantage Plan, we'll talk about later, but they act the same way. That these are the one situations where your name is on the check as well, or the demand if you don't pay them. So it's important we do this right. And those you do, I'm sure everybody here does Medicare conditional payments in their office, probably really love it because it's so fun and easy and there's never a problem. The exact opposite is true. Medicare is really good at one thing, and that is causing mistakes. I get lots of calls from attorneys or paralegals who feel like they're blaming themselves for some error with Medicare. It almost is never your fault. It is always Medicare's fault. A lot of things play into that, and I'll go through the process here in a few slides, but some of the things that come up, for example, are letters crossed in the mail. Medicare has a 40-day turnaround time on correspondence. So you send them a letter, in your office, you probably respond in 24 hours, 48 hours, 72 hours. They respond in 40 days. So you may be waiting for a response. You send them another letter. Their next letter responds to your first letter, and you're wondering why they didn't respond to your second letter. That is very typical of Medicare. So it is understanding how the machine moves that is really key, and quite frankly, the value we add at Synergy. The processes are the same. You guys do this in your office right now. But making sure that all the I's get dotted, all the T's get crossed in exactly the right way, so there isn't some unnecessary delay, is where we can help. And I'm going to go through one of the processes called the final conditional payment process, which is really beneficial, will speed up the resolution, and should speed up getting the checks at the end of the case. So there is some positive news about Medicare we'll talk about. Okay, we're not starting on positive news, we're starting on bad news. Some of you may have seen this, came out earlier this week where a Philadelphia law firm agreed to resolve a case with Medicare. This case had really gotten out of hand in that the Department of Justice went after his attorney under the False Claims Act, and was really putting the screws on this attorney for doing what a lot of attorneys just do, which is just don't pay Medicare the final demand for an oversight, an error, whatever happens. What happened in this case, though, is the attorney had to pay a settlement to the government, agree to set up someone in his office who will specifically handle this and train them. The Department of Justice, as you see the quotes here, are pretty significant. They intend to come after attorneys and their clients who are not honoring these obligations. I think what's driving some of this is what's happening in the Medicare Advantage world. So we'll talk about that later, but I'm sure a lot of you heard about how Humana is kind of going after attorneys and doubling damages. You at least heard a little bit about that. And I think Medicare has the same ability to do that, but they never do. And I think I feel like the government is aware of what's happening in the private industry and the recoveries are being made there, and then I turn the screws more with traditional Medicare A and B. So I think that's kind of what's driving this. But to avoid this problem, where you're getting any kind of problem with Department of Justice or with BCRC or CMS or HHS or Department of Treasury or Pioneer Collections, who's their collection agent, is just going A, B, C, D, and making sure you do it all the right way. And we're going to walk through that pretty quickly. Step one, when you have a Medicare beneficiary as a client, is make sure you get the proper forms. And the forms you need, in particular, are proof of representation and the consent to release. Consent to release is just your HIPAA form. Medicare will accept your HIPAA form as sufficient. You don't need to use their particular form. For the proof of rep, you are going to use their form. And you send both those off to Medicare. If you're monitoring the Medicare portal, which I recommend you do, you can see when their authorizations have been received and when the case has moved from what they call open or in discovery or in development to open. And it'll show that your authorizations have been, quote, verified. So there's a couple steps in there beyond just sending the documentation over. But you send those forms to this Oklahoma City address. You can do it by the portal. You can do it by fax. You can do it by phone. But it's all going to Oklahoma. They will then set the case up on the portal, and you can look on the portal about 10 days after you've sent that in there. Now, one thing Medicare and their own instructions tell you, if you do not get the rights and responsibilities letter within 14 days, you need to call them back. They've made a mistake. Someone hasn't done it right. In fact, Medicare says to call back within a week, but I do think you can probably wait 2 weeks because you're supposed to get the rights and responsibilities letter at 14 days. So that'd be a good tickler in your file. If you don't get that letter, call Medicare up and make sure they did their job right. Or you can call us and we can check the portal real quickly to see if a file's been set up. When you report the case to Medicare, you're going to report everything about the case, your information, defense information, everything about the beneficiary. In particular, you're going to make sure you're as specific as possible relating to the nature of the injury suffered. You don't want to, if it's a broken arm, you want to put a broken arm there. You want to say, if it's a bad back, you don't want to say bad back. You want to say L4, L5. You want to be specific as possible because Medicare is going to add everything in from the date of injury forward. They're just going to do it. So you can control as much as you can control. I think it's a little bit like defensive driving. You can't control the other driver, but you can control what's in your control. So be as specific as possible when you're reporting to Medicare the nature of the injury. And from this point forward, you're going to need to use all the correspondence cover sheet every time you fax something to Medicare. This is the link to it. I believe you have the materials. But it's just a fax cover sheet. But without this cover sheet, they're throwing your letters away, 100%. I imagine it's a gigantic trash bin at CMS. They throw letters in without the fax cover sheet on it. Now, 65 days after the rights and responsibilities letter, so now you're 90 days out from when you reported it, and nothing speeds that up. So you don't want to do this early. So you're 90 days out from reporting the case to Medicare, you get your first conditional payment summary, the first time you get it in writing. You can view it on the portal, which if you're not using the portal in your office, I recommend doing that. It's a little bit cumbersome to get on the portal access. You have to do part of it online, and they mail you some information in the U.S. mail. You've got to sign up and Someone in your office has to be designated as the administrator, but that person is not supposed to use the portal. It's a little bit complicated, as everything was Medicare. But once you navigate that and are on the portal, that is a very useful tool. It allows you to monitor all your cases at one time, rather than what a lot of attorneys have done in the past was use their client's My Medicare login, and that's not nearly as good as the portal. You're going to want to use the portal if at all possible. Okay, so now you get your payment summary in, the things you're going to want to check are the diagnosis codes, the dates, are the charges correct, and the provider names. Everything, making sure it's correct. For example, Medicare often have a claim summary on there saying unspecified pain as a related charge. Well, it might be related, but it might be unrelated. I say I'm sitting here in my chair with unspecified pain in my lower back right now. I don't think it's related to an injury. So dispute those kind of charges. If they're not clearly related to your case, dispute them. You can dispute them in writing, which on the if you have your claim summary comes to you in writing, just circle the ones that are acceptable, put an X through ones that are not acceptable, and send it back to Medicare on the same letter they sent you. I used to get fancy, had beautiful reports and spreadsheets and all these worksheets. Medicare hated it. They want it super simple. Don't use a highlighter because it gets lost in scanning, and don't forget to use your correspondence cover sheet. You're also going to use if you're using the portal, you can dispute right on the portal. Just click the button and it goes through. One thing I'll point out in disputing, which is key, and we're having great success with this, and those of you who are looking at these Medicare audits will have a better idea what I'm talking about. When you get a Medicare claim summary, and the charges are bundled. So it might be that you have one itemized payment of $10,000, and then under that are 10 different individual treatment. Of those 10 individual treatment codes, one of them is related, 9 of them are unrelated. You need to dispute the unrelated ones, but Medicare is supposed to take off the entire bundle. Even if the reverse is true, even if 9 of the 10 charges are related and 1 is unrelated, Medicare is supposed to remove the entire bundle, even related charges. The reason they do that is a technological reason. They can't pull out individual charges. There's a case out of the Ninth Circuit, which I know is not controlling in all the circuits, but Medicare when it goes by it, that they have to remove the entire bundle. So make sure you're disputing as much as possible. You want to get this lien as low as possible so your client pays back as low as possible to Medicare. And you're doing it not a sharp practice. There's no fudging the numbers. You're playing by the Medicare rules, and you get the benefit of those. So just knowing the rules really helps quite a bit. So dispute, if you're in a normal process, we haven't done, what we'll talk about in a second, the sped up process, you can dispute as much as possible, 100 times, with adding increasing amounts of medical evidence. But what I want to talk about for kind of the rest of this before we switch over back to Jason, we'll talk about even better part of Medicare getting refunds, is what's called the final conditional payment process. This is a process only available on the portal. It started in 2016, and Medicare didn't say a single word about it, although it's the only good thing about Medicare. There's 2 things in this process. It's sort of like a rocket docket in that if you anticipate resolving your case in the next 4 months, on the portal, you click a little button that says, I want to go into the sped up process, 120-day final conditional payment process. You're allowed to go into it 1 time per case. So you click on it. And here's a little flow chart of how it works. I'm not sure how readable that is, but again, I think these materials are available to you. And if not, please contact me. This is on a blog on our website. But it's pretty straightforward in that once the case is set up, you go into the 120-day process, and it gives you 2 big benefits. One is in disputing. And that if you're in a sped up process and you dispute online, Medicare must respond to your dispute within 11 days. If they do not respond within 11 days, your dispute is automatically granted, just like a request for admission. As helpful as that is, you can only do that dispute 1 time, unlike the normal dispute process where I said there's an unlimited number. You can only do this dispute process 1 time. But the really big advantage of this process is the final conditional payment letter. When you know your case is going to settle, you have a mediation upcoming, a settlement conference, you believe there's a good chance of settling, you can download from the portal this final conditional payment letter. And what's great about this letter, it sets the conditional payment amount as a sum certain for 3 days. So if you download it today, you can settle the case today, tomorrow, or the day after with this number being their final conditional payment amount. So you can sit at the mediation table and tell your client what they're going to be netting. That's a huge benefit. I'm sure a lot of you are surprised you can do that, but you certainly can. The other big benefit of this letter is, as you can see, it's on CMS letterhead with clear instructions about how long the number is available for, how long it's certain for, and when you need to report it by. This letter you can use to get the defense counsel rather than making you wait to get a final demand. So it serves two really good purposes. Now, if you don't settle the case in 3 days or the mediation gets bumped, you're out of luck. Too bad. You can only do it one time. You're out of the process. There's no negative side effect to it. You just don't get those benefits. So I recommend taking advantage of it. Josh had a case in South Florida where we were able to achieve massive savings on this because Medicare had done whatever Medicare does and had a number that was hundreds of thousands of dollars less than we thought it should be. We locked it into this process, and that's the final demand number. The one thing is, this is the final conditional payment number. This number will still be reduced by procurement cost, and you will still get a final demand with payment instructions. This is useful for you to have a final number to settle your case. Then once you've settled your case, you can report it on the portal, like I was talking about, or you can send in what's called a final settlement detail document. Very straightforward document. It just asks you what the total settlement amount, the no-fault amount, attorney's fees, costs, and the date of the settlement. Medicare then apply their calculations, which are right here, and send you a final demand. Even if you're in the sped up process where you got the final conditional payment letter, Medicare, and once you report the settlement to Medicare, you're required to do that within 30 days of settlement. Medicare will still send you a final demand, which will be the amount of the conditional payment minus procurement costs, and it'll have a payment date, which will be 60 days after the date of that letter. These are the repayment calculation regulations. The big distinction is, was the settlement equal to or greater than the amount of the Medicare's conditional payments? If the settlement amount is equal to Medicare conditional payments amount are equal to or greater than the settlement, then you're going to get your fees and costs. Your client's going to get zero. Medicare is going to take all the rest. If the payments are less than your settlement, Medicare does a reduction for fees and cost. It essentially is a pro rata reduction for fees and cost. The formula is right there, but that's how it works out. Obviously, the first scenario, 41137D, is pretty draconian. We have lots of clients who are amazingly upset, as you might imagine, when their attorney's taking a $50,000 fee, Medicare's getting 150 grand, and they're getting zero. That happens all the time. Unfortunately, Jason is going to tell you a solution for that, and the reason we developed the solution Jason was talking about is because we had attorneys who are regularly stuck in that situation and would say, Dave, I'm just going to cut my fee and send my client 10 grand. You can't do that. It's considered Medicare fraud because Medicare bases their repayment upon the fee actually charged. So it was a catch-22. Luckily, we have a solution. Now, once you get the final demand, you've got to pay it. You have 60 days to pay that final demand. Nothing tolls that period of time. Not appeals, not waivers, not compromises, nothing. 60 days after the date of that, they'll start charging interest. Now, we'll talk about Medicare Advantage plans, what that means. Medicare technically here, after 60 days, could double the amount due. They could stop paying attorneys and stop producing attorneys fees and double the amount due. Medicare does not do that. Medicare, after 60 days, starts charging interest, which is about 10 or 11% right now. And then after 420 days, they refer the case to Department of Treasury. They start garnishing Social Security benefits, and eventually they hand it over to Pioneer Credit, who comes after your client. They have not been doubling the damages. Now, you'll pay the final demand. You'll then get a letter from Medicare saying, we got your check and X amount of dollars. Our file is now closed. That is the letter you're waiting for. That is the one that knows you are all good. Medicare's not going to reopen the file. They're not going to come send a new file demand out. If that happens, I'm sure some of you are thinking, well, I've gotten it before, Dave. That's a result of usually defense reporting incorrectly a settlement and Medicare inadvertently and erroneously opening an additional file. I think Jason will take over and spread some good news on Medicare refunds, and I'll come back to sour the rest of your day when we talk about Medicare Advantage plans.
Thanks, Dave. So, you guys are probably tired of hearing my voice since I am now on my fourth presentation, but you will be happy to know that this is my last presentation and will be fairly brief because while this is an important topic to understand, it really isn't all that complicated because really the answer truly is to get experts like us to assist with what I'm going to talk about, because we've got the process nailed and our results, which I'll talk about real briefly, speak for themselves. But Dave just went over Medicare conditional payments. I talked about earlier in the context of Section 111, how there's no way around reimbursement of Medicare and how personal injury attorneys have personal liability if you fail to reimburse Medicare. So what I'm going to talk about is what do you do to prevent Medicare from taking too big of a bite out of the apple in cases where, say, the amount that Medicare would be due is going to consume the entire amount or is too much in relation to what the client is recovering. So as Dave talked about, you can, to resolve Medicare conditional payments, either pay the amount, appeal it, during which interest continues to grow and grows at quite a staggering rate, 10 to 11%, as Dave said, or you can pay the final demand and seek a compromise or waiver of the Medicare conditional payment. And there's three different ways that you can get a potential compromise or waiver. And the reason that we advise clients to go this route versus appealing and really any other way of fighting a Medicare conditional payment is because when you pay the final demand, it stops the interest meter from running. And Treasury is not pursuing anybody. It stops everything dead, and it allows you to make the arguments that you would want to make, equity arguments, those types of arguments as to why the Medicare conditional payment should either be reduced or waived completely. So the three different ways are financial hardship waiver, compromise, and a best interest of the program waiver. If you are successful in a compromise or waiver request, then Medicare issues either a partial refund of what was paid to Medicare or a full refund if it's a complete waiver. So it's beautiful. It's a beautiful thing. So the methods under which you're requesting these waivers or compromises is under the federal laws exists. It's been there. It's part of either the Social Security Act or the Federal Claims Collection Act. So up on the screen, you see the different provisions. You can research it. The financial hardship waiver, which is one that's used pretty frequently and we've used in seven-figure recoveries to get a full waiver of a Medicare conditional payment. The way you do it looks funky because it's a Social Security form and doesn't make much sense. But all these methods are ways that we can, or you can, pursue either a partial or full refund back from Medicare. One of the beauties of this is that you can go back and get a refund on old cases. There's no statute of limitations, and we've had law firms who have done this for clients who they had settled for 5 years ago. And that client then gets a nice little refund check back from Medicare out of the blue, which they're going to attribute back to you, which is a beautiful thing in terms of PR for the law firm. So keep that in mind. It's not just for cases you've currently got in the hopper, but if you've had a big Medicare final demand that you've paid, we can go back and try and attempt to get a partial refund or a full refund. So what you see on the screen is actually what it looks like. You get a check back from BCRC, well, the client does, for whatever the amount of the waiver is. So the figures in the left-hand box are from 2017. So the success rate is 82% of the time. So 82% of the time we request a compromise or waiver, we get one. The total refunds in 2017 were just under 1.5 million. The average refunded amount to our clients was $20,000. And since we started providing this service, we've recovered over $4.2 million on behalf of Medicare beneficiaries. And as you can see, the top three refunds are quite large. I don't know which of the three it is, but one of those top three refunds is a case I actually had some involvement in on the planning side. And it was a tragic case. Mother and daughter, adult daughter, were shot. The adult daughter died. The mother of the adult daughter survived. She was elderly, but got a significant seven-figure recovery on a negligent security case. And we were able to get her Medicare conditional payment completely refunded, even though she had a seven-figure recovery. So I say that to emphasize that this is a extremely viable solution. No matter what the scenario is, it's worth a shot. So utilizing these methodologies, Synergy is very successful at getting money back from Medicare. Thus, we call it our Medicare refund service. And with that, I am done. You won't have to listen to my voice again. So that's either good or bad. So I believe that we are turning it back over to Dave again. And I think he's going to be talking about Medicare Advantage liens, which has become a really hot button issue. So I'm going to make him the presenter and let him take back over.
Thank you, Jason. Let me get my right slide. Okay, I believe everyone can see my slide now. And we're going to talk about Medicare Advantage plans, also known as MAO plans. That stands for Medicare Advantage Organizations. You see it said that it's often called MAO in legal opinions. It's also called Medicare Part C. You hear that often as well. Medicare Advantage really, at this point, is essentially just private Medicare. It was started back, and I love talking about it by the bipartisan days, and mentioned it was Gingrich and Clinton. The bipartisan days when Medicare Advantage was come up with. The idea was baby boomers were coming online, and they simply didn't have, Medicare didn't have the capacity to deal with all of them. So they developed the Medicare Advantage program. I think it's a great program. It combines Part A and Part B, as well as adds in other things, prescription services, vision, dental care. There's a variety of plans, but quite frankly, it's a pretty good option for elderly people. They often make the decision based upon their own medical needs, because sometimes it's more beneficial to be on Medicare rather than Medicare Advantage, depending on the medicines you're on. But overall, it's been a very useful tool. What's made it unhappy for trial attorneys recently is the way Medicare Advantage has sought after the Medicare Secondary Payer Act. Back when I wore a black hat, I did do recovery for Medicare Advantage plans. Humana was right there in Louisville with us. But back then, Medicare Advantage plans had to rely on their contract rights. They couldn't rely on the Medicare Secondary Payer Act. And most of their contracts did not have any recovery language in there at all. So most people just avoided paying them. That has certainly changed. Things have gotten very aggressive in the Medicare Advantage world. You're seeing attorneys getting sued personally. You're seeing double damages being levied against tortfeasors, carriers. So it is definitely a new world out there. One thing I want to point out before we delve too deep into Medicare Advantage, so just make sure we're talking the right thing. This is not Medicare supplements. Medicare supplements are private insurance. If your client has traditional Medicare A and B, and they have an AARP card or a Mutual of Omaha card or something like that, that's going to be a Medicare supplement, which is treated like private insurance. That's all it is just private insurance. If you're in an anti-subrogation state, you don't have to pay those back. If you're in Florida, 768 applies. Medicare Advantage is different. Medicare Advantage, it replaces it. And I'm going to talk about some of the differences, but I want to, the whole point of this discussion with you guys is to be heads up about this, because what Medicare Advantage plans are doing, Humana in particular, is taking advantage of the current state of logistics in discovering these plans. So what I want to focus on, as well as explain what Medicare Advantage is how to find these. And the problem arises, and I use my in-laws as a perfect example. My father-in-law's on Medicare Advantage, my mother-in-law's on Medicare A and B. If you ask them both who their insurance carrier is, they say Medicare. Because to them it is Medicare. In fact, if you have Medicare Advantage, you will get your red, white, and blue card from Medicare, but you won't be on Medicare. So you may even have the card. So your client might walk in to you, show you a Medicare card, you report the case to Medicare, and it's showing 0 the whole time. That means there's a Medicare Advantage plan out there. That is the single biggest red flag. If you're reporting the case to Medicare and it is showing 0 balance the entire time, no conditional payments have been made, somebody is paying those bills. You need to check the bills themselves, see payments by Humana or AARP or whoever's paying the bills. Go to your client, grill them for insurance cards. It's important because you are on the hook for it. Talk about some examples of that. But the slide we're looking at now is just talking about the private cause of action, which allows double damages if you don't repay Medicare, and the CFRs and opinions of CMS directors that extend that to Medicare Advantage plans. Now, I said earlier, Medicare is not doing this themselves. They're not double damaging. They can, but they don't. But Medicare Advantage plans are, Humana in particular. And as you see the slide here, you are specifically listed in the regulations as a liable party. We're not trying to sell fear, but you should be a little bit afraid out there. Back about 2 years ago now, I was an expert witness in the case here in Virginia in the Western District, where an attorney had been sued directly for $400,000, which was double damages, by Humana. Humana clearly knew the attorney had missed it. They waited for the time period to pass, and they went directly after him, never even bothering to sue or even notify the Medicare beneficiary. So that's important to realize that ERISA people worry about, but you're not on the hook for that unless you sign a separate contract agreeing to be on the hook for it. Medicaid, you're certainly need to deal with that, and there be things levied against you, fraud and theft even, against you for not honoring your Medicaid lien. But Medicare and Medicare Advantage are the only two you are personally liable to repay. And I've had delivered some bad news to attorneys over the years of paying out of their own firm pockets some pretty hefty numbers because they haven't paid Medicare back, and Medicare Advantage now is doubling down on that. So you really need to be aware of it. The repayment formula is the same, just like Medicare, exactly the same. I point out, though, that not all the recovery vendors agree. Rawlings in particular. In fact, at this point, it's only Rawlings. Rawlings is of the opinion, since their contract calls for 100% repayment, and their contract is approved by CMS, that they get 100% repayment. They are wrong. Do not pay them 100%. They do not get more money than the federal treasury. They don't have more rights than the government. They have no case law supporting their opinion. They have no statute supporting their opinion, but they are making millions of dollars by just saying those words. Push back on them. As we were talking about liens earlier, we fight on these things. Don't just pay them. There's no reason they shouldn't be reducing by attorney's fees and costs and procurement cost. The other thing I want to point out in this formula is Jason talked about the complex nature of the Medicare refund process. Medicare Advantage plans, you don't have to go through that process. They are allowed, because it's private industry, this is the one thing that's better about them. You can do all the negotiation before you make a payment to them. You don't have to do this ridiculous pay Medicare and then wait for a refund. Our argument with the Medicare Advantage plans are that if they're going to take advantage of the Medicare Secondary Payer Act and pretend to be Medicare, they have to at least do the same evaluations that Medicare does for financial hardship, under compromises, under best interest of the program, all of that. Now, they are allowed to evaluate and say, we don't agree, we're not paying, you pay us the whole thing. But they have to at least go through the motions. And what's important about that is, because it's done by private industry, Rawlings, Optum, they want you to pay them. They get paid a percentage, they're on a contingency fee. So they don't want to litigate, they don't want to fight. They want you to, they have to take a reduced repayment to get a case settled and money in the door, this is how they'll do it. So you can have that discussion, they can agree to a reduction, and you can just resolve it like that. They fight pretty hard on it, but that is the way to do it. You negotiate before you make the payment. There is no refunds process with Medicare Advantage plans. Now, the bad side, as I said, with the private cause of action, is pretty bad. 11th Circuit case, the Western Heritage case, was the big one that came out. The case I was involved in here in Virginia luckily got resolved before the 11th Circuit had issued their opinion on this, months before, very close. But what happened here was very typical of how attorneys practice. And a letter from Medicare saying no conditional payments due. Right before settlement of a slip and fall case, Humana shows up. Humana went after the plaintiff. Plaintiff said, I'll pay it, no problem. The defense carrier, Western Heritage, actually issued their settlement draft, including Humana on the check. The state court judge said, take Humana's name off the check, reissue a check. They did. The plaintiff did not pay Humana. Humana did a little bit of litigation, got tired of it, turned around and sued Western Heritage directly. Western Heritage put their $19,000 in trust, saying, let's litigate this thing, get an answer, we'll hold the money in trust. 11th Circuit said, putting the money in trust isn't paying. You didn't pay. You have to pay within 60 days. You didn't. And the statute says damages shall be double. We have no ability to reduce damages. Damages, therefore, shall be double. And even though no love is lost against the defense carrier, it is important to note they paid this 3 times. They paid the $19,000 value of the injury to the plaintiff, then had to pay it the amount double back to Humana. So that's why you're getting a lot of concern from the defense carriers about Medicare Advantage plans now, because they know they're on the hook. Because Humana is going after them and you, not even going after the plaintiff directly. So again, the takeaway from that is not to be terrified, but to be aware. In particular, if your Medicare conditional payment amount is showing 0 the whole time, find out who's paying those bills. That is different than the Medicare conditional payment amount being less than you expect. That is probably Medicare screwing up. But if it's 0, you need to really be aware of it. And thanks everyone for your time.
Good afternoon. This is Dan Alvarez from Synergy Settlements. I'm an attorney and founding partner of Synergy, and I'm bringing us in for a landing here today. The challenge of the format that we had today is in an effort to bring to you kind of quick hitting topics and work through a variety of issues quickly. It kind of took away our availability to answer questions in real time, and it didn't look to me like there was a whole bunch of activity in the chat box. So to everyone on the call, what we've really had thus far is half a conversation, and it would be our hope as an organization that you would connect with us. And frankly, the only way that we can be the resource that we want to be to you and your clients is learning more about your practice, your firm, your challenges, your opportunities. So as a next step, what I would suggest, those who heard information on the call that they're interested in following up on, please send me an email at dan@synergysettlements.com. Again, that's dan@synergysettlements.com. You can also schedule with the 877-2402-0022 number you see now on your presentation. But we'd love to spend, 15 to 30 minutes on a phone call, learn about your practice, learn about your challenges, learn about, where we can be an asset to you. We are not a one-size-fits-all, this is the solution organization. We're very proud of the resources that we've built. We're proud of the education that we believe we've all put together in a convenient way for the industry. But until we learn more about you, your practice, and your firm, it's difficult for me to throw slides up that say, this is exactly what you should do. I can tell you that as far as organizationally, we have the scale to handle everything from a single event to all of your firm's inventory in regards to lien resolution, Medicare compliance. We've got firms around the country that basically our involvement starts with a scanned copy of an insurance card and ends with full and final demand letters and special needs trusts and structured settlements and, a tip to tail analysis of the case and make sure that each of these issues are addressed. Today we focus kind of solely on those issues involving Medicare and things that spiral out from Medicare, but that really is only a piece of the Synergy model. We're also can bring expertise, whether it's ERISA, private insurance subrogation, funding status, whether it is self-funded or insured, and the debate that incurs, and that means a real lot to your client's bottom line. Disability plans, TRICARE, VA on the subrogation side, and then moving into the settlement planning space, answer questions like, is my client getting asset-sensitive benefits, and is there a method by which those benefits can be protected? Is there a trust that would benefit my client? Is there a structure that's going to make a difference in my client's life? As a formal personal injury lawyer, I understand, and frankly, as the people on this call who spent 3.5 hours of their Friday afternoon before Beach Week, you're involved in this call and you're involved in your practice because you care about your clients. And it's that genuine concern for your clients that fits so closely into what Synergy does. We believe that everything we do is an effort to either grow or protect the settlement proceeds that you work night and day to deliver to your client because something terrible happened to them or their families. And then that's a reality of our practices. And we're very proud to be that piece that can work to that goal of both protecting and growing the recovery you work so hard to establish. Again, thank you for sharing this time. We actually have 36 states represented on today's webinar, 2 Canadian provinces and Puerto Rico. We're grateful for everyone's time and the opportunity again to have our side of the conversation. We look forward to hearing your side of the conversation. The easiest way of doing so would be to email me at dan@synergysettlements.com. For those on the call going to the AAJ meeting in Denver in 10 days, please stop and see us. We will have an entire contingent there, and that would give us another opportunity to, again, continue the conversation and learn more about how we can be a resource to both your firm and your clients. Thanks again.